Okay, everyone, my name is Jeff Donnelly, as you're probably most likely aware. I'm just giving you an update for the people that have been following the criminal charges I'm facing right now. Today's early morning of December 10th, 2021. I went to court yesterday on December 9th for the criminal case involving my time working as a bouncer at the Magic Lantern and the bartender's false complaint that she made against me just about 6 years ago now. That wasn't filed until, a year ago. So it was it was just sitting there for 5 years before the district attorney's office made Lieutenant Gasparini, the Monson Police Department, file the charges, as he even wrote in his report that he was advised to file by ADA Parsons. Okay, I go into the first set of motions to dismiss in that case a couple videos ago, if you want to look at those, which were denied without even a hearing. Yeah, the judge wouldn't even let me argue the case. Either of those. Well, the first one. And then when I went actually to court to argue the second, the motion to dismiss, I was arrested and the court officers beat the hell out of me, plain and simple, for refusing to put on a mask. And then they refused to actually let me have that motion to dismiss heard that day as well, because they locked me up in the holding cell instead of bringing me upstairs to have that motion heard. Once again, you could watch me read my motion to dismiss in that case. Yeah, they're both long. Yeah, they're boring, but they're very informative. I do plan on making videos up strictly on what was alleged to have happened at the Magic Lantern by the bartender when I was a bouncer. But what I would like to mention about that is that the fact that the person sued the Magic Lantern relating to that, but they claim that, well, this would happen basically. Their shifts had been taken a couple weeks prior because they were a drug addict, an alcoholic, and also they were stealing tip money too. Or at least that's what's alleged. And then they made a complaint against me 3 weeks later. And then a couple weeks later, they filed a lawsuit against the club claiming that the club had retaliated against them for making the complaint against me by taking their shifts away, even though their shifts had already been taken away. Yeah, it makes no sense at all, but hey, it's Massachusetts, and if you want to lie, you can lie. Why not? So what happens is, when I went, I ended up getting arrested for refusing to put on the mask, which actually, after I did put on the mask, is when I was arrested in that case, by the court officers. Okay, so skip to yesterday. Well, whatever. I'm still awake. So skip to December 9th, motion to dismiss hearings. Okay, so I go in there for the motions to dismiss. Plain and simple. Ask yourself this. Is it fair for someone to face charges for serious crimes where you're looking at over 5 years, close to 10 years in jail, if you're found guilty? Is it fair that the police department can get away with deleting video footage, video evidence? Because that's what happened. In the Magic Lantern lawsuit, in Magic Lantern criminal complaint that's alleged based upon that, we have some major issues. The first issue is that Lieutenant Gasparini, who was a sergeant at the time, had told the alleged victim that he needed the clothing that this person was wearing, and that the clothing was really important to get a conviction in this case. The person refused to give the clothing up. Refused. Okay. Well, the clothing in that case is very important to this case. But they refused. These charges should be dropped just by that alone, because it's a he said, she said situation, and the clothing would have definitely disproved the person's, claim. Okay, but let's step further now. I went down there for a couple times, and gave statements. My statements never changed. At the time, Sergeant Gasparini had actually told me that the other person's statements had changed several times, each time that he had talked to this person. Okay. So, now we come to the simple fact that those statements don't exist. My statements don't exist anymore. Their statements don't exist anymore. Because the Monson Police Department deleted the footage, deleted the statements, deleted the evidence. This evidence would have cleared me because in the statements, Sergeant at the time, Gasparini, stated while the thing was recording that the person's statements have changed each time and mine has stayed the same. And because of that, I was not going to be facing charges. Okay, makes sense. Then again, makes sense that the charges wouldn't have been filed until the district attorney's office, 5 years later, ordered him to file the charges. Then we have another aspect of evidence in the same case. The magic lantern. Well, the problem here is that this individual, this bartender, was alleged to have been romantically involved with one of the owners of the Magic Lantern, which is Peter Pesolano. His brother, Mark Pesolano, is the one that took the shifts away from this individual, the bartending shifts, because the person was under the influence of drugs and alcohol and possibly stealing money. So they went from working like 4 days as a bartender, including Friday night, which is the big money night in a strip club, to working, like maybe Tuesday day shift, without looking at my papers, as a bartender in a dead club, which means that there's no money to be made in that kind of situation. And they were told that if they wanted to work Friday night, it had to be as a waitress, which once again, at the Magic Lantern strip club, was a dead night as a, waitress. Bartender makes money, waitresses don't. Okay, in a strip club. So what happens? Remember, she's romantically involved with Peter Pesolano. Peter Pesolano likes having her around because, for obvious reasons. But his brother, doesn't. Well, Peter Pesolano doesn't like me because I called him out for being a murderer for causing a girl to commit suicide. So for like the half a year leading up to this, me and Peter aren't talking because I called him out for bullying a girl so bad that she killed herself in front of the building. Yeah, go figure. So me and him aren't getting along, and this individual claims after the alleged activity happened that she made several different claims. One of the claims she made is that she called up Peter Pesolano, who lives right next door, and told him what happened. Another claim that she makes is that she went over there immediately and talked to Peter Pesolano about what allegedly happened. Then she makes another one where she drove to Kmart, called him, and then went back to his house and talked to him about what allegedly happened. Okay. So you have a guy who does not like me, who's Peter Pesolano, because, why? I called him a murderer in a text message after he and another management member of the Magic Lantern caused the girl to commit suicide in front of the building. So obviously, he doesn't want me there. His brother, Mark, wants me there because I'm the only adult in the building, and I'm reliable, and I've been a bouncer there for at the time it was maybe 6-7 years, with no issue. So I'm there. So that night, it's Peter Pesolano's night to work. Okay, so Peter Pesolano comes in, works. I'm not notified of anything that, this bartender, was alleging. No idea. So what happens is, maybe 6 hours later that night, the police come in, and they ask to take a look at the video footage. As a member of security, I know where all the video cameras are and what they pick up. Well, this alleged incident allegedly happened right under a video camera. The video camera covering the cash register would have covered this space right here. And this video camera would have showed that nothing happened. That the bartender was lying about the whole thing. Well, when the police show up, Peter Pesolano, who the bartender said she had spoke to, she had talked to in person, talked to on the phone, or whatever. No matter what, she says that she talked to this person who does not like me, claiming what she alleges happened. Okay, well, the police come in there, and there's no video footage. Supposedly, the video footage from that night doesn't exist. The cameras were not working. The police officer goes back the next day, talks to Mark Pesolano, the other owner. And once again, oh, the video footage from this night does not exist. The night before exists, the week before. I think there was 2 other nights that no video footage existed for. But remember something, this is a security system that's hardwired into the building, into the electrical, into the computer system. The only way that there would be no video footage of any footage in the building would be if someone went in there and actually deleted the footage. And on the night in question, when the cops showed up about 6 hours later, the only person with access to the office and computer system was Peter Pesolano, the person who was romantically involved with the bartender, and also the person who didn't like me because I called him out for murdering a girl, causing a girl to commit suicide. So let's see. If he would have watched the video and seen what she claimed happened, that video would have been saved and right away to the police. But if that video showed that she was lying, that video would have been deleted because it wouldn't help her. It wouldn't help him, overstepping his brother to have me no longer work there. Makes sense, doesn't it? The person had no reason at all to try to protect me in this situation, especially if you look at when this individual, this bartender, did sue the club, she actually sued the club, claiming, not for what she alleges that I did, which I didn't do, because me and her were friends. Me and this person were actually friends. She told the police on the night in question that she wanted nothing to do with me. Me and her were not friends. She kept her distance. But then again, later on, it came out and she admitted that up until that very day, me and her were actually very good friends. A friend doesn't make up shit. Plain and simple. But if you look at her Commission on Discrimination, Massachusetts Commission on Discrimination paperwork, it makes sense why she would lie, because she even writes in her complaint that the owners of the Magic Lantern, Peter Pesolano and Mark Pesolano, they like to pin employees against the employees in order to gather favors. So if you look at it, you have a drug addict who lost most of her shifts down to 1 bartending shift a week. She's got a house. She's got 2 kids. She had 2 kids at the time. And she needed money. So what did she do? She turned on a friend of hers in order to help Peter Pesolano out by getting rid of me. And hoping to get her shifts back. Because when she sued them claiming that after she made the complaint against me is when they took the shifts away from her, even though the shifts were taken beforehand. Okay. So getting back to the motion to dismiss. That right there is evidence that was destroyed, which would have cleared my name. So right now with the Magic Lantern situation, we have her refusal to turn in clothing, which Sergeant Gasparini had requested, said that he needed those to find me guilty, which could also be used to find me not guilty. Also, the video footage that the Monson Police Department took of my statements and her statements, which once again would have found me not guilty and found her not a credible witness. And you have the video footage of the Magic Lantern, which the Monson Police took Peter Pesolano at his word that the video cameras weren't running. And instead of actually taking or getting a motion, well, getting a warrant to take the hard drive from the computer or take the computer itself and actually look through the computer himself, or having a specialist actually look through it, or in general keep it as evidence, because if it would have been deleted, there was a good chance that it could have been in a delete file, or it could have actually been on another part of the computer, or another part of the hard drive, such as the trash bin. There was always that possibility. It was never checked, though. So right there, that's more evidence that's gone. Plus, this is over, at this point in time, I think it's been 6 years now that this alleged incident occurred. So when you look at that, I am sitting here facing, in this case alone, over about 5 years in jail. And what they've done is they've basically handcuffed me. They've handcuffed my hands behind my back, where I don't have the evidence that I need in order to defend this case to the fullest. Because, once again, clothing the individual refused to turn in. The Monson police videos were deleted. The Magic Lantern videos were deleted. Okay, so, boom. That charge, by that alone, should be deleted. If you want to know exactly why else it should be deleted, watch the video that I posted reading my original motion to dismiss. This motion to dismiss is just about what I just mentioned just now. Oh yeah. And in this one, Assistant District Attorney Joyce is upset because we have to go back to court on February 15th in order to argue this one again, because the judge refused to argue it. Well, he allowed it to be argued, but he refused to rule on it until we have another motion hearing on this in order to have the state bring witnesses to testify. Well, ADA Joyce has already admitted that the Monson Police Department told her that the evidence that they had, they deleted, which should have automatically been a dismissal today of these charges. But no, that's not how I guess it works. Because even though they've told her and she's admitted in court, now she's sitting there claiming, well, they didn't say that they ever recorded the bartender's statements. Come on. They did. That's why they had the bartender go to the police department, go in the interrogation room, and actually gave the statements several times. Because they were obviously recording it. Otherwise, they should have been recording it. Makes sense, right? And they already admitted that they deleted mine. So even deleting just mine should have been a dismissal today. But no, so we got to go back on the 15th. Okay. They told me to, call in summons, people from the Magic Lantern, such as the owners, in order to testify about the video surveillance system there. And ADA Joyce got really upset when the judge ordered that she summons Lieutenant Gasparini to give a statement and to be cross-examined about the evidence being missing, but also the bartender to be brought in and to actually give testimony in regards to refusal to turn in the clothing that were required. And also a few other things. So ADA Joyce was really upset about this situation, though, because she claimed, well, Mr. Donnelly's just going to badger her and harass her and blah, blah, blah. It's like, no, I'm not looking to badger or harass anyone. What I'm looking to do is I'm looking to defend myself so I don't go to jail. I'm looking to have these charges dismissed because the evidence has been destroyed or lost. And willfully destroyed, may I ask, by the alleged victim, because the evidence wouldn't have helped the lawsuit that they filed. And once again, may I let you tell you, she wants $1,280 from me. So I'm facing 5 years in prison on this, because she wants $1,280 for massages. And let me tell you this about the massages. The person who she claims that she got the massages through went to high school with her, and has already admitted that they've never did a massage on her in their life. Yet, she's falsely claiming that she had $1,280 worth of massages done, and she never did because that's what she wants me to pay her. And you know something? If they actually told me this, give her $1,280 and we'll dismiss that, I would say this: fuck you. Yes, I would actually say fuck you, and I would take this to a jury trial over giving her even $1, because that's what this person does. This person has a long history, which I'll get into in another video, of committing criminal offenses in order to get money. She's a convicted felon for staging a robbery at her apartment to cover her lighting her car on fire in order to collect the insurance money on that. And that right there is a, oh my, like, the statements that I got in this, Lord help you. They're fucking crazy. Like, the stuff that she claims, the stuff that other people have claimed in that case and everything else is just completely, like, nuts. She's actually a sex offender. Like, one of the statements I found in the paperwork, in the legal paperwork, was that she was in her early 20s dating a 15-year-old boy. And not only was she dating and sleeping with a 15-year-old boy when she was in her early 20s, which is statutory rape, which is actually rape. That's rape. But she was taking his money. So he had a part-time job at a grocery store, and everything he made, he gave to her. She would have him skip school in order to babysit her daughter and hang out with her. And this is from the kid's mother's own statement. It's a miracle that she was never charged with that, which kind of shows how the system is, that a woman in her early 20s can sleep with a 15-year-old boy, which is statutory rape, which is rape. But besides that, she could take all of his money, and he had $700 in his life savings bank account, which is a lot of money for a kid that's 15 years old, but she also had him give her all of that too. But okay. And a bunch of other stuff with this person, with police complaints and everything else, including even after, like, she made the complaint against me, she tried to make a similar complaint against another guy she was working at, who the owner of that business I had talked to and said, I thought that her and this guy were, like, dating. I thought they were together. I thought they were good. I'm like, hey, I thought that me and this girl were friends, too. We weren't even dating, but I thought we were friends. Even though she claims that we were friends. Nice way to treat a friend, though. But hey, when you're a drug addict and you need money, I guess every dollar helps. Okay. So, the ADA doesn't want her to have to testify because she thinks it's going to be harassment. The judge was like, no, she's got to testify to this. So at least I've got her testifying on the 15th of February on this, which is not going to go good for the state because realistically, I've got about 5, 6 different binders of evidence already collected, which shows exactly the character of person I'm dealing with here. And I mean, these are convictions and everything else. Yeah. I've never been convicted of any criminal offense in my life. I worked in DYS. I was with the Springfield Park Rangers. I worked private security for many years in many high and sensitive locations. I've got the degrees in criminal justice and psychology, which are right over there. Like, I've dedicated my life to helping other people. Plain and simple. So, okay, now let's get down to the other motion to dismiss. The other one has to deal with when I went to court for the original motion to dismiss to be heard, and instead of allowing me to have it heard, I was sitting in a jail cell without even the right to a phone call, which is against Massachusetts general law, because if you're arrested, you're supposed to be given a phone call within an hour. They had me in there for about 3 to 4 hours without a phone call, which is highly illegal and a violation of Mass general law. Okay, but how about this? If you look at my other videos, you'll see the video of my motion to dismiss in that case, but more importantly, you'll see the video of what transpired in that case. Like, you'll see the conversation between me and Assistant Deputy Chief Cardozo, where I'm talking to her wherein they claim I was screaming, yelling, raising my voice, you know, like waving my arms around. But what you're going to love about this one is I was able to get a copy of the statements that four, I believe, court officers filled out. Well, the charging documents claim what I just told you. These claim something completely different happened. Even from the same person who wrote the one where I was yelling, screaming, waving my arms around. And you know why that is? Because they were able to watch the video, and the video showed exactly what happened. So they had to make statements that kind of complied and showed with what the visuals would actually show. But what they did do is they also stated that I told them that I was going to be suing them. Okay. And that after me telling them that I was going to sue them is when they claimed that they had to put hands on me and slam me against walls and put me in wrist locks and slam my head against this and against that, slam my knees against a metal bed. Yeah. But they all placed the blame on Assistant Deputy Chief Cardozo. Even the one that arrested me, that placed me in handcuffs, said that he was ordered to do it by Cardozo, who is also the one that I said I was going to be suing. And after I said that, she ordered them to arrest me, which is actually witness intimidation and a violation of the Massachusetts, the Americans with Disabilities Acts, because I told her I'm an asthmatic. I showed her my asthma medication, as you can see in the video that I posted. You know, like, it shows that she was very upset and she knew she was screwed. And now, the important part on that case. In that case, Assistant Deputy Chief Cardozo was the person who was responsible for saving the video footage of that whole interaction. And as soon as 30 days came up, or even, who knows, maybe even before that, she deleted all the video footage of the whole interaction. Can you believe that? Deleted all of the video footage of what she charged me with. So tell me that this is not destroying evidence. You've arrested someone for a crime. Everything has been recorded on video, and you delete that. So that's the second motion to dismiss, is based upon the individual involved in the interaction allowing the video to be deleted after 30 days. And the kicker, the court-appointed attorney that they had given me for that, I had told him that I needed a copy of those recordings. I had told him everything is it has been recorded. Yet, none of the recordings were saved. So once again, that case right there, besides my motion to dismiss, which I read in another video, which once again is probably boring for most people. You know, it's a long one. But once again, besides all that, the charges should be dismissed because they deleted the video footage. You know, wouldn't you agree that when the police, when law enforcement is deleting video footage, that charges should be dismissed? That only makes sense. We're living in America, but are we really living in America? Because last I knew, we had rights under the Constitution. All of this falls under the due process clause. You know, like our rights under due process. And equal protection of the law. Like, see, like, oh yeah, and equal protection of the law. It's December 10th right now. I filed charges against the bartender back in mid-August. And yet, they've still not scheduled that for a show cause hearing. Why? I get charges filed against me and I'm arraigned 2 days later without even notification that there's an arraignment. I'm called up by the Monson Police Department and told that I've got an arraignment. That's 2 days later. I filed charges, and how many months have gone by? Mid-August to mid-December, and yet no show cause hearing for them. And theirs is based on perjury and destroying evidence and everything else. You know, like in making false statements. Currently. Not 5 years ago. Well, yeah, 5 years ago, 6 years ago now. But also currently. I'm telling you, man, like, we're going down the rabbit hole with all of this shit, you know. I'm going to touch base in other aspects of corruption, too, on this channel. Because corruption is just... it's screwy when the government's doing it to you, you know. When your own government, the United States of America, people who work for the government, people who work for the state are actually doing a political hit job on you. Oh, yeah. And motions to dismiss, discovery motions I filed, which the ADA said I was going on a fishing expedition looking for and stuff like that. No. Remember, I'm fighting for my life right now. And when you're a defendant and you're fighting for your life, you should have discovery. And when you have someone claiming major psychological issues, claiming that you're the one that is causing these major psychological issues for the last 5 years, yet they've claimed that against other people as well. Like, I think 4 or 5 other people at least have been, this person's alleged the same thing about psychological issues affecting them. Well, yes, I do believe that I should have access to their psychiatric records and their counseling records and their psychiatry records, because they do mention those. They do mention the therapy that they alleged to have received from these facilities. And I think that if I get them and they show that I'm not the one being complained about, it's all these other people, then I shouldn't be saddled with that burden, you know, of being responsible for this person's mental conditions. And once again, remember, this person's a severe drug addict and a habitual liar for the past 20 years or something, and even after, even to today. I believe that right there, I should have access to for obvious reasons. Also, I requested medical records because this person claims that what happened affected her condition of sciatica, which this person claims was almost healed, but even 5 or 6 years later, it hasn't healed at all since 5 years ago. But also, this person claims that they broke their tailbone twice, but not claiming I broke it. But their ex-husband, who I talked to, told me that it's bullshit, that it doesn't exist, didn't happen. So once again, I'm looking for medical records to disprove what this person's claiming happened. You know, so I'm looking for a double negative if you get down to it. So how do you find that? By having the whole medical record going back, like, you know, as far as back as you can, because legally can, because it shows that this person's not complaining of sciatica, that this person didn't have these breaks and ruptures happened, and it just shows, once again, the person's lying trying to get money. You know, it's sad that this person is all about money. Also, I requested any records that the Department of Unemployment has, because, once again, they applied for unemployment when they were finally fired from the Magic Lantern, because she went after the owner verbally while he was intoxicated, and he said, just get the hell out of here. And she took that as being fired. So, you know, because she was upset that he didn't tip her. He didn't give her money, so she got mad and started yelling at him while he was intoxicated. Go figure. Yeah, you really want to do that to someone. Unless you're looking to get fired, which she was. So, what I was looking for is the unemployment records when she applied for unemployment against the club, and what she claimed, and what they claimed to deny her, because I did hear that they did deny that claim. And also the places she worked after the fact, you know, if she applied for unemployment from them, and what she claimed and what they claimed, because realistically she made a very similar allegation against them that she did against the Lantern, involving another individual. who, once again, like I had already said, had been friendly. She had been friends with, you know? And the owner had thought that she was romantically involved with. And was surprised when I provided him with the documentation that she made with the Spencer Police Department about his business and about her. Because, once again, she tried to sue him in a small claims case, in a small claims court, not for being assaulted, as she claims, but claiming that he stole money from her. I'll get into that in another, video as well, because it's just completely fucking crazy. Okay, and also I requested, production of documents, subpoenas for documents for a couple law firms, because I believe that there's a non-disclosure agreement that is in effect, which she can't discuss what she alleged happened, because she took money from the Magic Lantern in order to drop the charges. Well, in order to drop her lawsuit against her litigation. Even though she said that she was only given, she settled for not much money. I think it was a couple grand or something, maybe $2,000 or something that she got out of that, because she had no case, because she was lying. And because obviously you lose your shifts this week, you make a claim this week, and then you claim that you lost them on this week. No. There's records of that. So they gave her probably about a couple of grand just to, as a nuisance lawsuit, just to save themselves a lot more money in attorney's fees. Because as everyone knows, that if an attorney has to write a motion, it's going to be more than a couple of grand for that motion. And a reply motion and to go to court to fight the motion. So they paid her a little bit of money, nuisance fee. They had her sign a non-disclosure agreement. When I sued them, I didn't sign a non-disclosure agreement. And I got a hell of a lot more than a couple grand. But she said that they didn't have any money. And that's why she only got a couple grand. Yeah, she's going after me for $1,280, which would have actually been covered by the money that the Magic Lantern had given her also. So yes, I'm looking for that non-disclosure agreement. I'm also looking for the settlement offer. Because for all I know, they gave her $1,280 for massages even, and she's trying to double dip in this. And once again, like I said, I won't even give her a fucking dollar to settle this, to drop these charges. I would take it to a jury trial over $1 even, because this person is a complete scumbag. So I am looking for those legal records, because the statements that might be involved, might be included in them, could help my defense. Settlement offers could help my defense, and other statements that she made could help my defense, because the one document that I have been able to get from that, case has really given me a lot of information. A lot of information. I'll go into that sooner or later as well, in another video. But once again, I went to court today for 2 motions to dismiss, which should have been dismissed because the evidence has been discarded. And it's proven that the evidence has been discarded. ADA Joyce admitted that in previous days to this one, that Gasparini admitted that the videos, the interrogation videos and such, were deleted. The court officer deleted the other video, deleted the other video of the interactions that happened in the courthouse. Those right there, automatic dismissal. The clothing, Gasparini wrote in his report that he told this person, how he needed it, why he needed it, the importance of it, and that they refused to turn it in and destroyed it. There you go. And the fact that in his statement he even wrote that the other video from the club was destroyed. That's why charges get dismissed, is because evidence gets willfully destroyed. And you might say accidentally. I say willfully, but at the very least, accidentally lost and destroyed. But it looks more like intentional. Okay, so that should have been dismissed already. But right now, I'm waiting on Judge McKay or whatever. McKay, I believe it is, from Palmer District Court. I'm waiting on him to rule to see if he is dismissing him, which, because we have another hearing on the 15th, I highly doubt that he's going to dismiss him, even though he should. And also his rulings on the discovery information that I requested, because it is needed, especially seeing that it's been over 5 years. And a fishing expedition, I'm sorry to say this, but when it comes down to discovery, if you knew all of the information that existed, you wouldn't have to file a discovery. If you knew such and such documents existed, you wouldn't have to file discovery in order to get these documents, because you would already have them. But if you want to call it fishing, I did fish on the other discovery when I asked for the trial court officer's statements, because the trial court refused to provide them without another judge's order from the district attorney's office asking for them. So if you look at that one, those statements, the trial court department refused to turn over to the district attorney's office, even though I had a motion to make the district attorney's office turn those over if they existed. If they existed. So then the district attorney's office had to contact the trial court department to ask if they existed. And when they were told they did exist, they were required to file another motion with the court, with the trial court actually, with the district court, to have the trial court provide those statements. So yes, those statements are going to help my defense if this goes to a trial. But if I didn't go on a fishing expedition to find the existence of these statements, I would have never had these physical statements in hand. And that is why I'm going after the medical records, the psychiatric records, the unemployment records, and the legal records, all involving this former bartender. Oh yeah, and how about this one? When I was working at Red Robin in Wilbraham as a waiter, guess who came in? The bartender. She didn't come in as a customer. She parked right next to my car. Yeah, right next to my 96 Mustang, which has a black bottom, green top, aftermarket fenders, front fenders, aftermarket body kit. It's a very unique car. But yeah, she parked right next to my car, went in, talked to a manager, and applied for a job to work with me. You can't make this up. Like, you really can't make this up. We were friends. I would have helped her with just about anything, just because we were friends. After she made the original complaint, I didn't do anything. I could have gone after her for like making false complaints and stuff back then, but I didn't, because I understood why she did what she did, because she needed money. But now that I'm facing charges off of this, and this is affecting my life, I have to fight back. I have to file charges against her. There's a possibility of a lawsuit against her as well. Like, did I want to have to do this? No. But I'm the type of person, if you come after me, I return the favor. She's going after me hardcore right now. But the thing is, you have to ask yourself this: is she really going after me? Is it really all her? The district attorney's office, the ADA, does not want her to have to testify on February 15th. Why? Because they know that this is a bullshit sham case. And they know that it's only going to hurt their case having her testify. And remember, they've filed false charges against me before. And most of the charges that they filed have been dismissed on the day of trial. On the day of trial, they've come in and said, we're dismissing these charges today. We're not going to a jury trial today. We're dismissing the charges. And that's what I think they planned on doing in this case. And now they're very upset. They're very worried that she has to take the stand, that they have to subpoena her on the 15th of February. And that's going to be one hell of a day. You know? It's not fair. But you see, they used this from over 5 years ago to file charges. They piggybacked the Springfield case off of this one, and then they made another case of me in the courthouse. Because on that day, if you look at the video, I even say the ADA wasn't ready on that day to have that motion to dismiss the heard. So what did she do? She had me arrested. Because remember something, ADA Parsons is the one that reached out to the bartender and had her agree to be a witness in this case 5 years later. And then having her put in the $1,280. That's the fee that they're paying her to go after me, is the $1,280. Unless there's been more money paid through the victims fund, which is a possibility too. The Springfield case, who initiated that? The Hamden County District Attorney's Office, once again, same District Attorney's Office as instituted this one, contacted the Deputy Chief in Springfield and had the Springfield case filed. So, if you get down to it, the Hamden County District Attorney's Office is corrupt as the day is long and has been involved in all of this. And what even like, hits the nail even more on the, hits the nail, like with the hammer even more so, is when I called up the District Attorney's Office as a pro se litigant who has the ability to actually meet with the District Attorney in the ADAs involved in this case, in all my cases, no reply back when I called up asking for a meeting to bring all my evidence down and show how this is malicious prosecution at its fullest. But you know what happens? The very next day I get a call from a probation officer in Springfield District Court. Well, telling me I'm on probation, I have to check in, I have to call her up every so often, I have to tell her this, I have to tell her that. Well, there's a problem with that. I'm not on pretrial probation. Pretrial probation in Massachusetts, it's either a way to end a case, which is an agreement between the ADA, District Attorney's Office, the defendant, and the court, which says if you don't get in trouble for this long, the charges are going to be dismissed and there's not going to be any record of it. Okay. I was offered that in the Springfield case. I refused. Or probation is given because you're found guilty of a crime. I asked her for paperwork putting me on probation. She sends me the paperwork months later saying I'm on pretrial conditions. Which, yes, I'm on pretrial conditions. Like everyone who's arraigned for a crime goes on pretrial conditions. It means that you cannot commit another crime while you're awaiting trial on the criminal activity that you're facing charges on. It says if you if you are arrested for another crime during this period of release, that you could be subject to 90 days in jail without the possibility of bail. It doesn't put you on probation where you have to check in with a probation officer every so often. In fact, the only time that it says I have to check in with a probation or the court is if I change my address, or change my contact information, such as my phone number, so the court would have up-to-date information to be able to contact me if they need to send me anything or, contact me for not going to court or something. So right there. And yes, I have text messages between me and this probation officer where I'm telling her this, and she's not replying to it because she knows she's fucked. And once again, this was the day after I tried to meet with the District Attorney's Office, mentioning, malicious prosecution. It just basically was a way for them to have a probation officer contact me and just let me know that I may be walking around the street free, but I'm not really free. Because if you look at it, when I was attacked by the court officers for not wearing the mask on that day, they were actually trying to hold me without bail. On that, they were trying to take advantage of the whole pretrial conditions of release and not being charged with a new crime. Thank God the judge did not hold me, but on top of it, that was their way of saying, look, we have you right where we want you. Shut the fuck up and do what we want to tell you. Do what we do what we tell you to do. And don't speak up. Don't speak your mind. Okay, well, more videos will be soon to come. I plan on getting into the original stuff that was done to me back like in 2009, because this isn't new. They've been going after me nonstop since I was 25 years old and took out papers to run for Congress as a common sense Republican. Before that, I worked in my field. I went to work in law enforcement every day, went home, did my thing, and just wanted to fight for the people. After that, after I took out papers, you know, I got blacklisted at my field and I landed at a strip club as a bouncer, working, helping, you know, exotic dancers and, you know, help them as much as I could. You know, I went from being a youth prison guard to, you know, like protecting at-risk women. You know, it's sad. I was making under minimum wage working as a bouncer in a strip club just to try to keep some form of my career, my life intact. And that just, they've beaten me down, plain and simple. You know, if you want, you know, if you want to help out my cause, donations can be sent through PayPal to JP Donnelly, JP DONNELLY 8 at AOL.com with PayPal. If you want to buy a book, my books are the book I wrote, Exposing Corruption, from what happened back originally, which I thought was the worst that they could actually do, which, boy, was I wrong. Well, that book is Raw Emotion and Political Repression, The True Tale of Massachusetts Bohemian, and that book could be purchased for $20, you know, through my PayPal, you know, or, you know, what you could do is, you know, like if it's person to person, it's $20. If you're having me send it to you, it's $25, and that's just to cover some of the shipping and handling to get it to you. The cover price of the book is $25 anyways, so $25, the full load is including shipping and handling. $20 is person to person, and for every book that I do send out to you, I will include a, you know, small piece of artwork, you know, just a really simple sketch, or a trading card, or even a postcard. But something will be included with every book purchased in order to give you a little extra, and to, you know, have something you can actually use at the same time as even a bookmark. You know, a little print can be used as a bookmark, a trading card, a bookmark. You know, a woodblock print to a few of you could be a, you know, bookmark. The woodblock prints, you know, are actually, I sell those for around, starting at $20 and going up. So if one of those is included, it's going to be a $20 woodblock print with a $20 book anyways. Okay. So once again, hopefully you like, hopefully you share, and hopefully you help me out by donating something to the cause. Okay. Once again, Jeff Donnelly. Have a great day.